Good evening, everyone.
Good evening.
Good evening.
Evening.
Oh, sounds ready to go.
Good evening.
Good evening. Sounds ready to go. Yes? Oh, Lord. All that good evening, we had such bursts of energy. Now I hear like, okay, we're dragging along. We'll get there. I hope not.
Oh, boy.
Can't be that bad. Okay, so we're on chapter 4, unit 4. Company
Yes.
incorporation. All right. I hope you had a chance to read the chapter. Yes.
I wasn't able to go through it. We had a rough
Yes,
everything.
this was actually, I wasn't able, this one chapter I wasn't able to go through yet. I was so disappointed.
Oh, okay. It sounds sad. Anyhow, so let's talk about company incorporation. So, start with opposite radio. What's required to incorporate a company?
What type of company?
Either, don't forget now, one side has the Companies Act and the other group has the IBC Act. So what's required under the Companies Act to incorporate a company?
Directors. Memo and arts. Solid name.
A trade name?
A name,
Yeah,
you need a
name.
name. You need a name. Whether it's a number, whether it's another language, you need a name.
You need a board?
To incorporate
We're
a
talking
company?
about the
No.
process when the
No.
form, right? Like the actual start of it, like get a name, fill out the onboarding, KYC, documents like that. Annual state.
Two
Uh,
directors? You need to have at least two directors?
yeah, but okay. So if you were to incorporate a company now, right? What does the act require you need to have?
Your memo and arts.
Your memo and arts. And what's in the memo and
Your
arts?
capital. And
The name of the company, the registered agent
whatever.
office.
Shares.
The par value of the shares.
Mm-hmm.
The jurisdiction, the RARO.
The type of company.
Are we only talking about?
And the Companies Act, you need the annual, the statutory declaration.
To incorporate a company?
The memo and art is the only document required to file.
You're asking or you're saying?
For the IBC Act, for sure, you need the compliance
of
certificate.
compliance, right.
Yes, yes. But under the Companies Act, what do you need?
The certificate of incorporation.
To
Don't you need the
incorporate.
affidavit?
The memo and arts.
You just need the memo and
So the affidavit and the statutory declaration, that doesn't upload as well? Sorry, I'm not in the Company Act team. I'm
Which
just asking.
affidavit?
we're trying to figure that out because that's not in the legislation.
No? I thought I saw that in the book. My bad then. I thought I saw some of the affidavit to sign.
Companies Act.
Yeah, let me look for it.
Okay, so let me start with the Companies Act first. So you know you have to do the memo and arts. So what does the memo contain? The memorandum. The name of the company, the registered
Mhm.
office, the activities it's going to undertake, the share capital, and the class of shares, as Makita said. So you need 2 or more persons to incorporate the company with or without limited liability. And they have to sign it and submit it to the registrar.
With a witness, right?
Mm-hmm. And you have to make sure that they're not underage. They have to be of sound mind and they can't be bankrupt. Then you need I see what you're talking about. The statutory declaration is by an attorney. That to the best of their knowledge, no signatory to the memorandum is an individual who is either under the age of 18 or of unsound mind, or they are bankrupt. So if you go to the Companies Act,
Mhm.
what section? That is what is required. Don't forget now, you have what the
Part two?
what's in, yeah, you have what's in the legislation itself, and then you have what we call best practice.
Good night.
I see in the
Good night. So under part 2, 3, it speaks to legal formalities. It says 2 or more persons may incorporate a with or without limited liability by signing a memorandum and submitting it to the registrar. Save that in the case of a nonprofit company, such signing of the memorandum shall be by 2 or more individuals. Then they tell you the criteria.
Mhm.
And then it says under section 3, if the memorandum submitted to the registrar manually or electronically is accompanied by a declaration by a counsel and attorney that to the best of his knowledge and belief, no signatory to the memorandum is an individual described in subsection 2. The declaration is, for the purposes of this act, conclusive of the facts declared therein. So they asked you for the memorandum, and they said if a statutory declaration is prepared, then it's evidence that the persons have all of the criteria in order to execute the document. Then what does it say after that?
The liability.
So the limiting the liability of members. And then it says the memorandum of the company with limited liability. So it speaks to that. So the name of the proposed company has the words limited or LTD. And the location of the registered office, the liability, the capital. No subscriber may take less than 1 share. Each subscriber to the memorandum shall write opposite his name the number of shares he takes and the number of shareholders. And then it goes on to speak about whether the memorandum and the company is limited by guarantee what is required. So they say a memorandum of a company under section 8, subsection 2 says the memorandum of a company limited both by shares and by guarantee shall state the number of shares and the value of each share with which the company proposes to be registered. And the memorandum shall be signed by each subscriber in the presence of at least 1 witness who shall attest his signature. Then they go on to start to speak about the articles of association. Articles signed by the subscribers to the memorandum should be filed with the registrar in respect of each company not less than 6 months after the issue of the certificate of incorporation. That's what the act says, but what is the practice?
They get filed together.
They file together. But you can see that the legislation does not require you to file them together.
Mhm.
So if you go, okay, that's about the name. Can't have identical name. So if you go to the IBC Act, and in most cases, these things are very similar. What does it say you need to do to incorporate a company under the IBC Act? You see the wording is very similar. Subject to requirements, part 2, again, section 3. Subject to requirements of this act, 2 or more persons may, by subscribing to a memorandum, incorporate a company under this act. The memorandum may be submitted to the registrar manually or electronically. And then it says, next thing it says that it has to be presented either by an FCSP or a licensee under the Banks and Trust Companies Regulations Act.
I don't know what to do.
You found it?
That's page 10.
What page? On my notes is 14. Part 2 in the IBC Act,
Yeah. Well,
Section
mine's-
3, 4,
And then 4, 1 and 2.
yes. And then 5,
Mhm.
a company shall not be incorporated under this act, A, for the purposes of facilitating any criminal activity or for any object or purpose which is prohibited by the act. So remember, I told you that when you incorporate a company, you no longer put exactly what it is that you're going to do. You can actually do any business that you want to do, but the type of business you do will be on your business license. So the act actually states what is required for you to incorporate a company. Now, what's the difference between the memorandum and the articles of association?
The
What's
articles
the
is
difference
like
in those?
the guidelines by which the company operates.
One is internal and one is
The
external.
articles? Yes, it's the same thing Marquita said. So what's in the articles?
The powers of like what the directors have, the objectives of the, look at the different guidelines on how the company shall operate or who has power to do what.
Right, so it
Shares.
speaks about, go ahead,
Sorry, I was saying the shares and transmissions, shares.
yes.
Yeah.
So it speaks about who has the power to do what. What's a quorum for meetings? It talks about meetings. It talks about when a director resigns, when one is appointed, how it should be carried out. It speaks about the seal, when should the seal be used. It speaks about auditing. It speaks about the shares, like you said. It actually sets out the powers of the directors.
Mhm.
So if the articles are silent on a particular topic, where do you go for instruction?
Would it be the act?
So say you wanted more information on the voting rights and proxies. Where would you go? You looked at the section in the articles, but you need more information. Where would you go to get that additional information? So you said in the act, so tell us the section.
Uh,
Sections 1 through 9? No?
1 through 9?
No, under the Companies Act 1992, as amended.
Okay. You're looking at the Companies Act, what section are you gonna look at?
10 and 11.
10 and 11.
And, yeah,
10? Okay, so let's go to 10.
So we on the 92 Act now?
Mhm.
Okay.
So if we go to section 10 in the Companies Act, so we wanted to get some more information on voting rights, right? So you say go to section 10. What does section 10 tell you with voting rights? In the Companies Act? Do you see anything in there about voting
No.
rights? Okay, all right. So give me another section. Voting rights and proxies.
That's
One
from
try-
either one?
No. What do you mean either one what?
You mean from either the Companies Act or the IBC Act?
Yeah. But she was looking at the Companies Act. You're talking about we want more information on voting rights and proxies. She said go to the act. So I'm asking her what section?
Hmm. So section 4, sorry, 6,
And which one?
IBC.
Section 6. I don't like this consolidated thing. This is not my kind of thing. Hold on. Section 6. 4. Okay. So what does it speak about? No, it doesn't speak about that.
In section 6,
No, not on mine.
quorum, voting,
Under section. Not in my copy. Everybody have this. You have that under section 6?
protection of members and creditors, notice of meeting of members. Quorum for meeting of members, voting by members, consent of members, no?
I have that as 50.
That's 60 something for me.
I have it as 50 on mine.
60 and down.
Okay, so if you wanted to know about a meeting under the IBC Act, 60, 60 speaks to the protection. But what is it under the Companies Act?
I think it's 167, but I can't find the space. Well,
167?
okay, never mind.
No, I looking for it. I just saying the number, but you said. Why you saying it like that? 167. I go in to look for 167.
How many meetings?
What do you have under 167?
Subject to subsection 2, each member of each class of members of a nonprofit company shall have one vote. The articles of a nonprofit company may provide that each member of a specified class shall have more than one vote or shall have no vote.
What about 72? Not 72, but like in the 70s.
Yeah, I
for the
was looking at
meetings.
72.
71.
73,
71.
74. They're talking about the different types of meeting, the place of meeting, the meetings outside the Bahamas and quorums, voting at meetings and evidence of meetings on 76.
Mm-hmm. They speak about
Representative of
proxies.
another body and joint on 77.
So if you wanted to know how a proxy is executed at a meeting under either act, what does it say you should do?
Can you repeat that question, please?
If you wanted to know how a proxy is executed at a meeting, looking at either act, what does it say? How do you execute a proxy?
Well, this one's saying subject to subsection 2, any member of a company entitled to attend and vote at a meeting of the company shall be entitled to appoint another person, whether member or not, and his proxy to attend the vote in his stead, and a proxy appointed to attend and vote instead of a member shall also have the same right as the member to speak at the meeting. And then it goes on to say, unless the articles otherwise provide, subsection 1 shall not apply in the case of a company having a capital share. A member of a company shall not be entitled to appoint more than one proxy to attend on the same occasion, and a proxy shall not be entitled to vote except on a poll.
Okay. I want you to turn to the back of your company's act.
What do you mean the back? The last
Very
page?
last. The last section. After all of the sections of the act, they have, let me see if I can direct you. Go to the first schedule.
Okay, hold on. 510. Okay, yeah, Articles of Association.
Right. So under this section here, this first schedule, this is the template for Articles of Association. Whenever your articles are silent and you want to know how something is to be carried out, the first thing you read, of course, is the act. But then you can go to this first schedule here, and it actually explains a lot of the questions that you have in carrying out certain activities. So let's say you wanted to transfer shares. Look at paragraph 17. It actually tells you how the instrument should be worded.
Mm. Like a default,
Yes.
unless you
Yeah.
change some stuff
Uh-huh.
inside it.
So let's just say you wanted, this is what it is. An instrument doing a proxy. That's in 65, 66. It actually tells you how it should be written out. If you wanted to know how votes are to be carried out, then paragraph 59 tells you how to do it.
Okay.
Then if you go to 74, 74 speaks about the rotation of directors. Any of you read this section before?
Nope.
Did you know it existed?
No.
Now you know, right?
Fortunately,
Looking at this, I see why, like every year when you have to do the AGM
Mm-hmm.
and reappoint the directors on ordinary
Yeah.
companies.
Uh-huh.
So that's where this would have come from this then.
Uh-huh.
Mm.
So unless the articles have something contrary, most of your action would come from this section right here. So normally when you incorporate a company, you either create your own rules or you follow these rules here. And these rules explain what you should do and how things should be done.
and so Ms. Asha, I have a question about this. Does anything update? I see that it's amended this year and that year, like 1992, 2005, and all those things. Would this change if any amendments come up?
I don't remember this schedule being changed. I don't recall this being changed. He said actually gives a lot of the things that you need to know is here. Proceedings of directors. How do you deal with dividends and reserve? Let's see, I think there was also something here on when the seal should be used. I just saw that section in here.
That's the same 73, right before 74, with a rotation of directors.
Yeah, they spoke to it. So if you go to the act, what does the act say? For a seal.
It says, the seal of a company shall not be affixed to any instrument except by the authority of a resolution of the directors, and in the presence of at least 2 directors, and of the secretary of such other person as the directors may appoint for the purpose. And those 2 directors and secretary or other person as aforesaid shall sign every instrument to which the seal of the company is so affixed in their presence.
Okay, so we go to section 26 of the act. And the act says itself, in the main act, it says, company shall have a common seal with its name engraved thereon in legible characters. It authorized by its articles, a company may, if it authorized by its articles, a company may have for use in any country other than the Bahamas, or for use in any district or place not situated in the Bahamas, an official seal, which shall be a facsimile of the common seal of the company, with the addition on its face of the name of every country, district, or place where it is to be used. Have you ever seen that?
No, I never read that.
Because normally it just has the address of the registered office here.
Or
Every
just
document.
common seal in the middle,
Mm-hmm.
and then the name of the company on the outside. I mean, like around the circle.
Right, but they say with the addition on its face of the name of every country, district, or place where it is to be used. Then subsection 3 says, every document to which an seal of the company is duly affixed shall bind the company as if it has been sealed with the common seal of the company. A company made by instrument in writing under its common seal authorize any person appointed for that purpose to affix the company's official seal to any document to which the party in the country, district, or where its official seal can be used. Any person dealing with an agent appointed pursuant to subsection 4 In reliance on the instrument conferring the authority, assume that the authority of the agent is during the period, if any, mentioned in the instrument, or if no period is so mentioned, until that person has access of the revocation or determination of the authority. Section 26 is the law, and the fee schedule under paragraph 73 tells you how to use it. You learned something new tonight, right?
Yep.
Yep. So for a Companies Act company, the main documents are memo and arts, including the declaration, certificate of incorporation. You need a share certificate book, for forms. You need the seal. You need a nameplate, register of members, register of directors and officers, register of mortgages and charges. If it is held by nominee shares, you need a declaration of trust. You have the first director's minutes. And of course, you have the shareholders agreement. What's the shareholder agreement?
Is that the same thing as the resolution?
No.
Sorry, what you was asking for?
What is the shareholders agreement? What is that?
Like a-
That's the document where you transfer from the subscribers to the actual shareholder.
Check section 73 of the Companies Act. I think my numbers don't go with this, that's not lining up.
Is it an agreement about how the company should operate?
Yes. So what does section 73 say? Or mine say 73. What's your number?
73. All the
Okay.
shareholders of a company among themselves, or all the shareholders of a company and a person who's not a shareholder of a company may by a written agreement restrict in whole or in part the powers of the directors of the company to manage the business and affairs of the company. And such agreement, if not otherwise invalid, shall be valid.
Subsection 2.
A shareholder who is a party to any unanimous shareholder agreement has all the rights, powers, and duties, and incurs all the liabilities of a director of the company to which the agreement relates, to the extent that the agreement restricts the discretion or powers of the directors to manage the business and affairs of the company, and the directors are thereby relieved of their duties and liabilities to the same extent.
So subsection 3 says, if a person who is the beneficial owner of all the issued shares of a company, a written declaration that restricts in whole or in part the powers of the directors to manage the business and affairs of the company, the declaration shall constitute a unanimous shareholder
What's
agreement.
the section for y'all for that?
What, in the
Yeah, I love
Companies
the
Act?
number because I don't have the same number.
We're in, let me see, this is under part,
3, section 73.
but she has a different thing up.
Yeah. Part 3. Okay.
More to the end of 3. Under the subheading meetings and proceedings. You see it?
Mm-mm. Meetings and proceedings.
Yeah, it's a subheading, meetings and proceedings.
Okay,
Okay, so go down through there and you should see.
that's 70 for me.
Well, how you want, what consolidated one you have?
My 73 says place of meeting, so it wasn't lining up. I mean, who was talking just now? It wasn't the same word in.
Oh. Well, she and I have the same wording for 73. So look for where it says unanimous shareholder agreement.
Mm. This the Companies Act, right?
Yeah,
Oh, that's 78. Okay.
oh, and under the IBC Act, who found the section of the IBC Act?
I found it.
Section 41?
41, yeah.
In most instances, the wordings are usually the same. It's the same.
Section 41 speaks to unanimous shareholders agreement. Is that what we're looking for?
That's it. Yes, that's it. Yes, that's it.
Okay.
Now stay.
Oh, you mean as the Companies Act? Yes.
So let me ask you something, Ms. Archer.
Mhm.
If you're the promoter, if you want to start the company, you'll be considered the promoter, then you do it yourself instead of paying an attorney for these services.
No, promoter is something else. We can come to that afterwards. Yeah, we'll come to that afterwards. So, do you think it's really necessary to have a nameplate? Is that a requirement by, or is that a requirement by law?
Lloyd.
Have a nameplate.
When it has a physical, what is it, mortar?
Present?
Has a physical presence. I mean, for the most part, the IBCs don't have physical presence here.
Okay, so under the act, there shouldn't be a section that speaks to that. Go ahead. In the
I didn't
past,
hear you, Ms. Archer. I'm saying in the past, just I think all of the registered office had nameplates. They actually had but I think that has been done away with.
okay. And someone look it up under the Companies Act. I could give you a hint, but I'll let you find it.
Well, sorry, what we looking for in it?
What we looking for? Sorry.
Nameplate.
Nameplate?
Let me just read that again.
You did? I don't think so.
When you was reading,
Yeah, no, I said you need to have a nameplate. So I said, I'll find it in law.
oh,
That's section 12.
12 in which act?
I'm looking at the IBC. Sorry, let me just go there before I say it's that, because I saw a name and I'm going to section
Yeah,
12.
okay, so section 12. I'm turning to 12.
Right, okay.
So 12 speaks about the name itself, remember? Limited LTD.
240.
Right.
No, not that.
Yes.
Yes, who say yes? Who said yes?
That's not I.
Would you find under the Companies Act?
Are you wrong?
Go to section, in my book is 21. I don't know what it is in yours, Makita. Section 21, Companies Act.
what a company is,
Mm-hmm. And mine.
that would be, amount of consideration.
No,
What is name on the side?
the name on the side is publication of name.
Oh, I
Complication of name
Publication.
or publication of name?
And 180, they have name displayed as different than. Is it a
For
foreign
where?
company?
IBC?
Yes, no, the Companies Act 180. A foreign company registered under the act and carrying on an undertaking in the Bahamas shall paint or affix its name and place of business in a conspicuous place in easy legible letters and keep that information so painted and affixed on the outside of its registered office in the Bahamas, in every office or place in the Bahamas in which it carries on its undertaking.
Yeah, that's the foreign company, but in general,
Okay.
there's a general clause that covers all companies
I don't see
that
that.
are incorporated under the Companies Act.
Ms. Archer, is that the section that says every company incorporated or registered under the act shall have its name
Yes, section 21.
painted or affixed? Yeah.
Read
Read it?
Yeah, right.
This is the
Every
Companies
company
Act or the IBC?
incorporated. This is the
Act.
Companies Act. This is the Companies Act, section 21.
Oh,
Yeah,
I'm in the next.
it says,
IBC, yeah.
find it? Says every company incorporated or registered
Yes.
under this act shall have its name painted or affixed and shall keep such name painted or affixed on the outside of every office or place in which the business of the company is carried on, or in any corridor, passage, or hallway adjacent or proximate thereto, in a conspicuous position, in letters easily legible, engraved in legible characters on its seal, typed, printed, or stamped in legible characters on all notices, advertisements, and other official publications of the company, typed, printed, or stamped in all bills of exchange, promissory notes, endorsements, checks, and orders for money or goods purporting to be signed by or on behalf of such company, and typed, printed, or stamped on all bills of parcels, invoices, receipts, and letters of credit of the company.
Yes. So you see? Now, as you were saying earlier, there was a time long ago, before 2000, where every company, including IBCs, had their name on a wall. There were long lists. But now most people just have a directory inside their office because they provide registered office and registered agents They'll actually have a like a directory inside, but before the names used to be on the outside of the building. Before we did the IBC Act. So I want you to look at the checklist for company incorporation, post incorporation. So we would have said, you know, the process is you reserve the name. You know, the name can be in words or numbers, limited, LTD. What if you want to incorporate a company and it is very close to an existing company? What do you do? Or what can you do?
Well, you request a review, eh?
Yes, at the registry.
What
At
do you
the
mean review?
registrar.
You could ask them to review the name.
And what do they do?
If it's too similar, they reject it.
Okay. So let's go and see what the act says.
And mind you, now you have to do that online.
Yeah, but let's see what the legislation says. Don't forget now, online just means it's a tool. You still have to follow the law. So what happens if your name is very close? By law, what should happen?
In the Companies Act now again?
Companies Act, and someone can look in the IBC Act.
Registered first.
Companies Act is 12.
So it's 15 in the companies apply.
So under section 12 of the Companies Act, what does it say? No company shall be incorporated under the act under a name that is identical with that under which an existing company is already incorporated. Under the former act or any other act concerned with the incorporation of companies or which so nearly resembles such other name as to be calculated to deceive or confuse, except where the company in existence is in the course of being dissolved or signifies its consent in such as the registrar approves.
Mm. So you could get
So it's not-
permission from the directors or something then?
You'll have to write to the company and ask their permission.
Mm.
And then that has to go to the registrar. What happens if you have certain words in your name or you use certain words? So let's say you want to form a company and you say your name is Roundtree Financial Limited.
The financial is the problem, I think.
Right.
Yeah, I think it'll.
Right.
Which
So any
word can be
words,
used.
uh-huh. So that's subsection B under 12.
To see if I can.
12B. Without express prior permission of the registrar, which permission may be withheld without assigning a reason. If you use the words assurance, bank, building, society, chamber of commerce, chartered cooperative, exchange, imperial, insurance, municipal, royal. So then it says under subsection 12, subsection 2 says, where a company is incorporated under a name that is identical with a name under which a company in existence is already incorporated or so nearly resembles the name of another company in existence which is already incorporated as to be calculated to deceive or confuse, the registrar may, whether or not the consent of the company in existence has been obtained, pursuant to subsection 1A, give notice to the last registered company to change its name, and if it fails to do so within 60 days from the date of the notice, the registrar shall direct the company to change its name to such name as the registrar deems appropriate. And the registrar shall publish a notice of the change in the Gazette. If a company changes its name, does it impact its obligations? If a
No.
company changes its name,
It depends. I mean,
on what?
on what they change it
The
to.
part
If
of the name they change, eh?
yeah, if it's still, how I can put this?
Sorry, Mr. Question.
If a company changes its name, does it impact any of its rights or its obligations?
But it said, change of name shall not affect any rights or obligation of the company or render defective any legal, I guess not, because it's saying.
No, it does not. Subsection
Oh,
5.
yeah, okay.
I missing see that.
Yes.
I'm missing it.
And then what section 13 says? The words limited or LTD
Must be
Must
part of
be
the
part.
name. Mhm.
Every company incorporated under Act. Yeah.
with limited liability. So you can either use the full or the abbreviated.
Mhm. Or LTD.
Mhm. So what section 14 says?
Sorry, can you go back to where you said if the company changes its obligation?
No, the changes its name. Does it,
Mhm.
right, does it impact its rights or obligations? Subsection 5 says no.
No.
Okay.
And then your name can be limited spelled out or it can be LTD. That's section 13. What does section 14 say?
Where the minister is satisfied that an association is about to be incorporated as a limited liability company for the purpose of promoting objects that are religious, charitable, educational, scientific, historical, fraternal, literary, sporting, artistic, or athletic, and that the profits, if any, and other income are to be applied to the promotion of those objects, or that there is a prohibition of any dividend or refund of contribution to its members, the minister may by license authorize that the association be incorporated without the word limited in its name.
Mm-hmm. Well, that sounds familiar to you?
NPO.
That sounds like nonprofit. Mhm.
Yes. So what if you decide you don't want the words limited at all?
You can make that decision, eh?
Who makes it?
The minister makes that, eh?
The registrar as well, eh?
Yes, subsection 14B,
Yeah.
just below that.
Mm-hmm.
It says the minister may by license authorize the company to make by resolution a change in its name, including or omitting the word limited. Is that it?
Uh-huh.
And subsection 3 shall apply to a change of name under this subsection.
Mm-hmm. And all of this applies to nonprofit. This whole section 14
Okay.
applies to nonprofit. So if we go back now to the list, we know about the share certificate book, we know about the nameplate, we know about the seal. Then they say you have to make an application to the exchange control. Why?
There's a foreign beneficial owner. That's what it is.
Yes. Mm-hmm. And so if the beneficial owner is foreign, you have to apply the exchange control for approval. Now, along with that approval, before it is given, the next step has to be done.
But
Why
Ms.
do you
Archer,
have-
that only pertains, Archer, that only pertains to a CAC, huh? Not to an
No, not to a
IBC.
local, not to a local one. No, not IBC.
Right.
So why do you have to apply to the NEC?
If they make an investment,
If they're making an
No,
investment? So they
their money is considered foreign. Their money is not considered Bahamian. So when forming a company, a Bahamian company here, they have to get approval for the use of foreign currency. No?
Mhm, yes, but they also have to be approved as an investor.
Right,
To enter into the country, they have to be approved as an investor.
right. So you have to make application.
Right. And then when that approval is given from the NEC to the BIA, the Bahamas Investment Authority, that approval goes to exchange control.
Okay, so it's not just the one application to the central bank?
No, you have to you have to apply to the Bahamas Investment Authority, who then places your matter on the agenda of the National Economic Council.
I see.
So, and the Prime Minister is on that council.
Yes, ma'am, the competent authority.
Yeah, so once that body approves it, then it goes back to the BIA, and the BIA then tells exchange control that the government has approved the investor, and you could go ahead with the exchange control part of it. Because you know the Bahamas has certain sectors that are carved out just for Bahamians. And then there's certain sectors just for foreigners.
Like when, if the shares transfer, or
Yeah.
with the foreign companies?
Mm-hmm. Yes. So if you look at the incorporation of an IBC versus a company, and go back to the very first class we had when we talking about the advantages and the disadvantages of incorporating the company, a sole proprietorship, and a partnership. If you were just starting business, we all agree you probably do a sole proprietorship. If you decided that your business is beginning to flourish, then you need some investors. So then you would actually have to form an actual company. And then if you decide that you need even more money, you can actually go public. So you see a lot of the things that you do in order to incorporate a company is actually laid out in the legislation. And then over time, people have created their templates to accompany what the instruction says in the legislation. So I want us to turn now to looking at what happens before the company is incorporated. A person who's going out there, who is making different arrangements. So let's just say you are a promoter. So that promoter could be an attorney. He could be a banker. He could even be one of the directors to be. So he's all about trying to find an office. He's trying to order furniture. He's trying to get your license. Maybe the building has to have some renovations done. So he's in the process of doing these things. So when you speak about a promoter, it's being defined as, it's usually summed up in a single word, a number of business operations familiar to the commercial world by which a company is generally brought into existence. So sometimes they say the promoter is the person who drafts the legal documents, or the person who nominates the directors, or the person who arranges the pricing of the shares. They're all called promoters. But you'd find in company law, there are some persons who, before the company is even formed, they're out there and they're entering into contracts. And the question is whether or not they are liable when they enter into these contracts, or the company ratify these contracts afterwards. So I want you to go to the Companies Act, go to section 22. It's in your notes, but it's good when you read it from the act itself.
The pre-incorporation contract?
Pre-incorporation. It says a person who enters into a written contract in the name of or on behalf of a company before it is incorporated is personally bound.
Oh.
And he is entitled to all the benefits. Remember now, the company is not incorporated. Now, he can, if he wishes to, put a clause in that contract which actually would state that he is not bound by the contract, or he is not entitled to any benefit from the contract. He can put that in that contract. However, once the company is incorporated, the company can go ahead and adopt the written contract. So once the company adopts the written contract that was agreed to by the promoter, the company then becomes bound by the contract, and the company then is entitled to all the benefits of the contract. Now, the promoter may say, guess what? When I entered into this contract, there were some benefits in here that I wanted for myself. And he can go to the court and explain to the court that there were some benefits that he wanted applied to himself. And some were actually for the company. And the court can decide whether or not it's going to apportion any benefits or liabilities between the two, between the promoter and the company. So a lot of people don't realize that when you go around and you're doing the, what we call the preparatory work for a company, and you start entering into contracts to make repairs, entering in a contract for the electrician to come, entering in a contract to ordering cars. If those contracts are not ratified by the board after its incorporation, that promoter is personally bound by those contracts. So even though you are a promoter, you can still make a profit. But as in anything, in being a promoter, you have to be able to disclose an interest. So let's say you're a promoter and you have a painting company. You can't just go ahead and have your workers paint the building without disclosing to the company that I am going to hire my company. These are the quotes that I got and I can do it lower. Because the company itself has to agree that they're going to pay you. So in the case that I have here in the notes, Gluckstein versus Barnes.
You can spell it, please.
Where, spell it?
Yes.
Gluckstein
Okay.
versus Barnes, Barnes.
Thanks.
So in here, the promoter was making a profit of 20,000 pounds. And the company went into liquidation and they wanted to recover the undisclosed secret profit that the promoter made. And the court said that if there had been a disclosure by the promoters in regard to the 40,000 and the 20,000 profit to themselves as directors, it would have been okay, but they had to do it before an independent board. Remember, whenever you make a disclosure and you need an approval, normally, based upon common law, it's done before an independent board. And that was established in the case of Erlanger and New Sombrero Phosphate Company, where it says that a promoter has to obtain approval from an independent board. It says the boards of private companies are unlikely to be entirely independent of the promoter of the company. And this was realized from when they did the Solomon case, Solomon versus Solomon. If a company issues a prospectus, disclosure to the shareholders may be made in it, and the shareholders give their consent by conduct when they apply for the shares being issued under prospectus. Disclosure by a person in his capacity as promoter to himself and his capacity as director is not enough. So in order to protect himself, a promoter should always get an independent disclosure statement made. So what if a promoter is selling a property? What is his liability? So if a promoter is selling a property, he could either do it before he became a promoter, or he can do it after he became a promoter. So if he was a property was purchased by the promoter before he became a promoter, but he doesn't disclose his interest in the sale, the company can rescind the contract. If the company wants to keep it, they could do so, but they can't recover the profit. Normally what is done is you sue the promoter for damages. Because in your eyes, the company has suffered. So think about it. Here he is, he owned a piece of property and now he wants to sell it to the company. And he's a promoter. He has to disclose his interests. Because if he doesn't, the company can rescind the contract. Or they could keep the property and then ask the court for damages. So what if the property that the promoter is trying to sell to the company was after he became a promoter.
What do you mean
Again, they,
after he owned it after he became a promoter?
yes,
He still has to disclose.
yes, he does. And the company again has a remedy where they can rescind the contract. So rescission is always available. Now, what happened if the company resold the property to a third party?
This is an innocent third party.
If it's innocent, then of course they take it for fair value and it's gone.
Right.
But he can't sue the promoter
Yes. 'Cause
for the profit that he made.
Because it already gets sold to a third party.
Yes, if a third party purchases it without notice, having no idea, then he gets it for fair value. Only thing the company can do is sue the promoter. So you always have to look at, so you hire a promoter to help you get your company started. In most instances, and the best advice to give is that you drop a contract. If you are the promoter, you should drop a contract between you and the parties who are going to be the shareholders of the company, so that the liability is spread between all parties. Otherwise, you as a promoter will be personally liable. Even though you can benefit from it, you will be personally liable. So even if as a promoter, you would have drafted a prospectus trying to get investors and information in it is false, then the company can turn around and sue you.
After it's incorporated.
Yes, it can sue you. So let's just say as a group of investors, you hire a promoter to find you a business to run. And the promoter selects a business that loses money. What do you think happens?
It would be the promoter's fault?
You think so?
I don't think so. I mean, because if you hire someone to look for something and you go along with it, you have to sign a contract.
not necessarily.
I heard someone say not necessarily.
I think it all depends on the circumstances. I could have a conversation with somebody and say, hey, I'm thinking of forming a company to sell lollipops. You think anybody would be interested? And they go off and they find somebody. Well, that wasn't really a contract, that was a conversation.
Okay, so look at it as a promoter. A promoter has certain duties. So if you're going to hire someone as a promoter, you have to make sure that they have the requisite skills and experience and qualifications to do the job that you ask them to do. That's the first thing. And whenever a promoter asks, his duty to whoever has contracted him is the same as if a director had a duty to a company. So the duties of a promoter don't end on the incorporation of a company, nor does it end after the board is appointed. But remember, once the company has acquired the property or business, which it was formed to manage, the initial capital has been raised, and the board has taken over the management from the promoters. The promoters' duties terminate. So go back to the question. If a promoter, you're looking for a business, they find a business for you, and the business loses money, is the promoter liable?
Why
Yes.
did the business lose money?
Once the company has acquired the property and the business has been formed to manage, the board has been selected, capital paid, the board turns it over to management, the promoter's out of the picture. You can't turn around and sue him and say, you selected a business that is failing.
It's just,
It's no longer his
now
responsibility.
I understand the question.
Now you getting it?
Yeah, I
Okay,
didn't understand the question in the beginning. Now I
Okay.
understand the question.
right.
Come give another example too. I think I just get it just now myself.
All right, so a promoter, you have asked a promoter, I've asked you to find me a business. I want to go into the cake baking business, but I don't want to start from scratch. I heard that there are like three small companies out there trying to find a buyer. I asked you to go and find one for me. Negotiate the price. What in the meantime, I'm going to be forming my company. So you come back and you say, all right, Mary Sue Ellen Bakery is out of the three. I've done all of my review. It's the best one. That's the one the company should purchase. So I have my company formed. I issue my shares to my shareholders. I form my little board. I appoint my manager with my 2 members of staff, or however small it is. But after a couple of months, I begin to lose money. Can I now go and sue you for selecting the
No.
wrong company? The answer is no.
No.
So give an example on an instance where they can sue them. Like with how you're saying if they don't express, I guess, certain interest in something.
Yeah. Now, if you engage a promoter, right, and the promoter then decides he wants to enter into a contract, knowing full well that one of the buildings he's going to purchase, let's say the building that he's going to purchase to renovate, he owns it. He owns it now. Before you even hired him, he knew he owned that building. But he decided that, guess what? Why should I go and buy or arrange with Linda for her building when I have a building myself? So he enters into a contract whereby the shareholders will be buying his building for their business. What's wrong with that?
But did he disclose to them?
No, he didn't disclose.
Did he disclose?
That's
No.
deceitful.
Yes, exactly.
And the other
So he
business would-
get paid for the building and
And
he
they
gets
don't
paid
know what
for
it
looking
is.
for it.
Exactly. So remember what I said before. The liability of the promoter as a seller of property may be considered under 2 headings. One is the property was purchased by the promoter before he acted as a promoter. And in that instance, if he did not disclose, the company may rescind the contract. And once they rescind the contract, the promoter has to pay them back the purchase price. Now, if the company decided, guess what? We're going to keep it. It's a good piece of property. It's a good building. We don't have to put too much into it. Only thing they can do then is say, guess what? The building costs on the market value, the building is worth $150. You sold it to us for $170. They're going to ask back for that $20,000.
Okay.
They're going to recover the profit.
But if they sell it for the 170, they don't get to recover the profit.
No,
Ask an
if that's the fair market value. But always remember, the promoter, whether he has the property before or even after, before he has to disclose and even after, he needs to disclose, and he has to be independent. He should always get independent advice. And even if it's a company that's going public and he is the promoter, which means he's out there having all the prospectuses printed, he's out there soliciting investors into the company, he has to be very careful that he does not misrepresent the company, because he can be sued again. So you have to be very careful when you take on this role as being a promoter.
So what's the benefit of being a promoter then?
You make a lot of money. You make a
sound like
lot of
you're
money.
losing more.
It's,
No.
you just have to be very careful.
So if you still
Okay.
have to be a
Go
promoter,
back to what our act says. Our act says, right? You could be a promoter. You could enter into the contracts, and it says under subsection 5, it says you can write into the contract that you are not to be bound by the contract and you are not going to benefit from the contract. You could expressly write that in the contract. But then, of course, if you were doing business with me and you're entering an agreement where I'm going to be doing all this work for you, and you're telling me that you're not bound, I need to know who's going to be bound.
Mhm.
But people do take on this job as being a promoter. It is a very lucrative business. But you have to make sure that the contracts are worded properly. So listen to this, and then I'll ask you a question. Lewis was the promoter of a company. It's formed to purchase a cotton mill and to carry on the business of cotton spinning. The memorandum and articles of the company were accepted by the Registrar of Companies on the 6th of January. And the certificate of incorporation was dated on that date, 6th of January. However, the certificate, it appeared, was not signed by the registrar until the 8th of January. What you saying just now?
I'm trying to understand how that could happen, but go ahead.
It happened. It happened.
How you know? How we know it gets signed on the 8th?
There's a date at the bottom.
I'll
When
give you
it's
the name of
signed
the
it?
case. I'll give you the name of the case afterwards,
Okay, continue.
so y'all can
Sorry.
look it up.
Yeah.
So on the 6th of January, a large number of fully paid shares were allotted to the vendors of the mill, and they were later transferred to Lewis. Remember, Lewis was the promoter. The question of the validity of the allotment arose in this case, and it was held that the certificate was conclusive as to the date on which the company was incorporated. A company is,
Again, please.
okay. The question of the validity of the allotment, remember, of the shares, arose in this case, and it was held that the certificate was conclusive as to the date on which the company was incorporated.
So it doesn't matter when the registrar signs it.
There you go.
It is valid on the day of incorporation.
Yes.
Okay.
It says a company is deemed to be incorporated from the day of the date on its certificate of incorporation.
Oh, noted.
And from the first moment of that date. Therefore, the allotment was not void on the ground that it was made before the company came into existence.
Which would have been on the 8th, you're saying?
Which would have been on the 6th.
6.
But you said, hold on, so when did they sign the
It's signed on the 8th.
It has nothing to do
It's
with
signed on the
signing.
8th.
Created
It's
on
the date of incorporations, when the company was formed and
No, I mean the
submitted
allotment of the shares. When did that go out?
on the 6th.
On the 6th.
Oh, okay, yeah.
On the 6th.
My practice, Ms. Archer, is always to distribute shares the day after incorporation. I don't know, I've just always done that, and it stood me in good stead.
Okay.
Because you could basically file your directors on the same day as incorporation as well, right?
You could.
You could,
I
yeah,
just-
you could.
I just do it the day after. I do all of my appointments the day after incorporation. It just works for me.
So what is the effect of incorporation?
What is the
What does that mean? What is the effect of it? What does it mean?
Means that the company is duly registered by the law of that land.
It's now in
Yes.
existence.
Uh-huh. And what else?
And that
Certified
all
they
the,
complied with the act.
That it
All
complies
the-
with the act. That's the first thing. And what else?
all the internal laws, what inside the memo and acts come into effect.
Yes. What else?
It becomes a separate legal entity.
Yes. Automatically. And it has what? Perpetual succession.
Mm-hmm.
Mhm.
But does the certificate of incorporation, does that tell you that the company is legal? This business is legal?
Yeah.
Yeah,
How?
Because it exists now.
yeah.
It's registered.
It's a separate.
So the company is registered, it's incorporated, which means that it now complies with all of the requirements under the Companies Act or under the IBC Act. And I'm asking you, does that also confirm to you that the business that the company is carrying out is legal?
Oh,
I
no.
mean, no,
Okay,
no,
all right.
they could be lying.
That's right.
So.
Dog say no.
Let me see what else I want to ask you. All right. Listen to this question carefully now. Let me see if I could do it. If the type takes too long, but I think you all are catching on very well. So scribble if you want to. Before the incorporation of House Limited, its promoter Bob entered into a contract on behalf of the company. The contract gave the uniformed company third-party rights.
The contract gave
The contract gave the unformed company third-party rights. That's me and my glasses, I can't see. Bob and House Limited
Gave third-party rights of House Limited.
No, the contract gave the unformed company third-party rights.
Yes. Okay. New
So
sentence.
who is liable? Who is liable if the contract is breached?
The company, eh?
Hold on. A, House Limited. B, Bob and House Limited. C, the shareholders of House Limited. And D, the directors of House Limited.
I think it's B.
Bob and House, whichever one that was.
I think Bob and the house.
So
Can you
did
repeat the question one more time?
Yeah.
Okay. Before the incorporation of House Limited, its promoter Bob entered into a contract on behalf of the company.
Okay, now I changed my answer.
What your answer is? The contract gave the unformed company third-party rights. Who is liable if the contract is later breached?
House, the company.
The
Bob.
Company, I think company.
Okay,
Or is it both? Because
think
it
it's
gives the company
On behalf of the company.
third-party rights, but then Bob didn't place anything in there to say he's not liable.
See, I
Company
need
was
one,
formed yet.
one
I
Or
think
is
it's,
it both?
Bob and the house.
Yeah,
On behalf of the company.
hold on now, some
but the
people going all
company
over the
wasn't
place.
The
formed
company
yet.
don't exist, so how it could be on behalf?
Right, the company
So
wasn't
Bob.
formed yet.
You could ratify that contract.
Bob.
I'm confused.
I think both.
I said
No, hold
Bob.
on, someone
I feel
confused.
both.
Hold on, someone is confused. I want a confused person to tell me what answer they'll give. Come, confused person. Why are you confused?
Bob. I think Bob because the
Because
company hadn't been
Bob
formed yet.
is a promoter. Bob is a duly appointed promoter. And Bob enters on behalf of enters into the contract on behalf of the company.
Mm-hmm.
Whether it's formed or not formed, that must be a part of the
No, I think it's the company, because it was, I don't know, I
be a
think it's
part
the
of the
company.
contract that Bob has with the company. So I would think that the company would be liable if there is breach.
Yeah, I go with the company too, because he ain't do it on his own. I don't know. Yeah, I go with the company.
So
If I
what?
wrong.
Ms.
Which
Archer,
one you-
read the question one more time.
Bob.
Yes.
Sweat.
I think I might should have put this on a final exam.
No, I'm saying it's both.
I
Where the
think
dog?
it's both.
I think
Okay,
it's just
hold
Bob.
on. Only two people
I-
say it's both.
I think it's Bob.
I
Okay.
agree.
Okay, I'm gonna read it again slowly. Before the incorporation of House Limited, the promoter entered into a contract on behalf of the company. The contract gave the unformed company third-party rights. Who is liable if the contract is later breached?
Bob and the company entered in the contract too. And the
B,
company
Right.
Bob
So
or-
both. So both of them. Both
Yeah.
of them.
That's
Bob
the
and the
answer.
Sorry, I
company.
had a blonde moment.
Okay, so the answer is B.
yes,
And B was Bob and the house.
Yes.
Yeah.
Yeah.
Bob and House Limited.
But I
Mhm.
And that's because
confused.
he went on it on behalf of the company and they had third party rights. So him being but first party. But they said they still had third party rights.
Yeah, but all they're saying is that he was a party to it.
Yeah.
Mhm.
Yeah.
It's a party to it. Okay. All right. You may need to write this one down. Joe and Fred wish to form a company.
They wish to form a company.
They wish to form a company.
Therese, come here.
Mhm.
So on the 1st of March, 2020, they filed the appropriate documents with the registrar. 1st of March, 2020. They filed the appropriate documents with the registrar. On the 10th of May, 2020, they received a certificate of incorporation dated the 1st of May, 2020. Later, they found out that the company had been registered on the 4th of May, 2020. On what date was the company incorporated?
On the 1st of May.
On
On
the
the
first.
1st of
On the
May.
first.
I given you some options. Wait.
Oh, yeah. Let me have these options. Sorry.
The 1st of March, 2020. The 1st of May, 2020. The 10th of May, 2020. Or the 4th of May, 2020.
Oh, they receive, you say
The
they
first-
receive.
The 1st of May,
The
2020.
first of May, 2020.
Hold
Hold on,
That's
hold
the
on.
date that was on
March.
the certificate. That's
Oh.
the date that was on the certificate. The 1st of May.
Oh.
Someone
know.
going through all the facts for you. They trying to figure out what is what.
No, it's but it's the 1st of May for me because I just remember you said, yeah, we just had one just like that. So it's the 1st of May. Yeah.
That's the 1st of May.
Okay. So that one was easy, right?
No.
Yes, it was.
Put someone on the test.
Let me see if I have another one.
Hey, this test could be hard.
What?
That's all I'm saying.
You need multiple
Stressing.
choice.
No.
It is?
This is not difficult. Not at all.
I think for me, Miss Archer, I think, you know, when you come from dynamic job at this hour, I see Lisa still at her office at this hour, and you're trying to make your brain function in a different manner. Yeah, that's what happens. I hope the next time we could do this on a Saturday class.
After I've
Oh,
slept.
yeah. It normally is on a Saturday, you know. It's normally on a Saturday.
It takes a while for my brain to get going. So you notice when I come in the evenings, I'm very quiet at the first half an hour or so.
Yes. And then afterwards, you on the ball. Okay, let me ask you this. Let me use someone in the class name so they could get Katina.
I know you
Katina.
won't call my name.
Yes. Katina is in the process of forming a company.
Go girl.
She
Speak it.
wishes to avoid personal liability upon any contracts she may enter into on behalf of the proposed company. Advisor.
Okay, so you're saying she's in the process of forming a company and she doesn't want any personal liability. What else?
Upon any contracts she may enter into.
Therefore, Miss Mal, you state up front in your contract with the people. And yeah, you give your, what is that word that we say at the bottom of the emails? Where you what's the D word? Oh Lord, what's it called? Your disclaimer.
Ah.
Mm-hmm.
Form a limited liability company.
Yeah.
Mm-hmm.
She's in the process of forming a company. She would
Yes, but
then
you make
have
your
to-
disclaimer,
she would
right,
then
Lisa?
have to enter into a contract as the promoter of the company herself, absolving herself of any liability.
Ah,
Uh-huh. So you go to section 22, subsection 5. Remember? In the act, where the promoter can expressly write within the contract.
yes,
Mhm.
yes.
Yeah.
Okay. That's the advice that you would give her. So in answering this question, how would you answer this in an exam? I think I should put this there.
Thank you.
How would you answer this?
Yeah, Katina.
Come on.
I guess you would
Let's-
quote
Can
the
advise
act.
herself?
So you say according to the Act of 22, subsection 5, it is expressly so provided in a written contract, a person who purported to act for or on behalf of a company before it is incorporated is not in any event bound by the contract or entitled to the benefits of the contract.
Okay.
Additionally,
So
if the company is formed, then you would want to form the company as a limited liability. And I would not be a director. I would appoint someone else as a director
mhm.
to avoid being penalized as a director. And then also with the shares, I would also distribute the shares to limit the amount of money that I would personally have to come out of pocket in the event of the liquidation of the company. I would only be liable for the shares that I hold. And I
Okay.
may even take it to the point of making it a public offering company to just get capital and let the public pay for anything else that needs to be done with the company.
So go ahead.
Is Katina in the process of forming a company as a promoter or forming a company just for herself?
but you can take it any way you want. It could be on behalf of someone or for herself.
Okay.
Depends on how she answers the question. But now, so you've given me from the middle. You first have to start out by saying, who is a promoter?
Oh, okay.
What kind of duty they have? Remember, they have a fiduciary duty, but they're not trustees.
Right.
So which means that they must have the experience and the skill to go with the job that they're saying that they're doing.
Okay.
And then you also have to state that if they have any personal interests, they have to declare it.
Ms.
So
Archer,
go ahead.
we could bring these acts to the exam.
Of course not. This is the whole point of you reading them now. Okay. I don't have my acts in front of me. What's the section that deals with seals? Don't look.
You have to know that?
No, I'm just asking.
Oh,
But you say don't look.
But I was like,
No,
no,
don't look.
sex? No.
Because we were talking about it for,
Well,
for
seals-
almost what?
Sales have to do it in corporation time. So let me see. I think.
Okay, Makita, where's seals in the first schedule?
Oh, that was.
Without looking.
But out look.
Yes. You're the one who pointed it out to me. Come on.
Okay, hold on. I think in patrol, hold on.
Come on.
I remember looking at the word. Hold on, I have to close my
Was it not
eyes.
paragraph 78?
But the Companies Act is 26.
No, it wasn't 78. You said the first schedule?
The first schedule of the Companies Act.
No, that wasn't 78. That was before the rotation of the directors.
Yes.
That was 73.
Something like that. Okay,
Because I
so
think
close.
the directors was 74 because he was talking about that first.
Right.
So you have to remember like those numbers, Patrol.
No,
Oh, child.
you don't have to remember those numbers. But you need to know what the act says. So you don't have to say if you answer question as per section 78 of the act. You should be able to say that, like for pre-incorporation, you should be able to say that the act permits the company to adopt a written contract that has been engaged in by the contractor, by the promoter. But the promoter can limit his liability by having a written contract whereby it expressly states that he's not to be bound by it.
I have a question. So
you have to know it by words.
Do you have a what the word called when you have like the practice test?
Mock exam.
Yes,
Yeah, so
that
past exams we could use.
mock.
What's all of this mock?
I need to know. I have to mentally prepare myself for what coming.
Okay, so those 3 questions I just gave you are past exam questions.
Could you email us one,
Okay.
please?
You just said them, they were very easy.
No. I think you need to email it so we could email a response.
Paper and and go over it.
Yes. Please.
Devin, man, you embarrassed.
What?
You talking to the dog?
That must be the dog. That must be the talking to the dog. Oh, Lord. Okay, all right then. Okay, so the same questions we had, I must send you I must write them out and send it.
But don't you have it already typed, Miss Archer? Can't you just scan?
You
They have
probably
other
have it with
questions
dance
on it.
already.
You already have the answers.
That ain't the same.
That ain't the same?
No.
Okay, all right.
We have the gist of the answers, not how you want the answers to be answered, not how you want the
Oh, I
question to
see,
be
okay.
answered.
Okay, I got you. Okay. I'll type it out and then I'll send it. I'll type it out. I think that'll be easier. But mock exam might not help you.
Wow.
Why? Because with every class, I write totally different questions. Same material, but I write different questions.
No, but what help us with the mock is the way we answer. Because you're looking for
okay,
answers in a specific way.
Okay, all
So
right.
at least if we practice that, that might help with some points.
And it helps to study the material easier when you know how to focus on an answer.
Mm-hmm. Okay. I just came up with a wonderful question. Okay.
Oh, wow.
Yes. Listen to this one. What if I say to you? What if I say Raven is a promoter and she is forming a private limited company. And I want you to advise her on the following matters. 1, what are the restrictions which exist for choice of name? Now, we did that tonight.
Must have a proper ending, cannot be identical to another company's name.
All of that, yes.
If you have something similar, you have to write the existing company and get authorization and still go through the registrar's approval before you can do that. Or the company must be dissolved on the dissolving state.
Right.
Okay, that's all I
You
know.
have certain, you cannot have certain particles to its name, for instance, insurance.
There you go,
fund,
financial and all the rest of that.
financial,
Yeah.
otherwise, and that, yes, and it must be, what is it? Cannot be owned by a foreigner. We're speaking of the CACs. Otherwise, approval will have to be gotten.
Right.
From Central Bank?
No.
No,
So
remember we went through all of that?
Yeah. The BIA to the NEC via the BIA.
Yes.
Via the BIA. And that approval is then sent to exchange control for the transfer of the shares to be held by a foreigner. Okay, so that's only one question you answered for her.
How many questions did you ask us? I thought it was just the one.
But y'all got so excited. Second question.
Oh, okay.
What documentation must she send to the registrar in order for the company to be incorporated, to have an incorporating status? What does she need?
Memorandum, the certificate of compliance. That's private, right?
Don't forget now, when you answer this question, you need to state whether you are quoting from under the IBC Act or the Companies Act.
Under the Companies Act.
That's why, remember, I tell you at the beginning, select which one. You can always look at both, like when we're in class. When it comes to the exam, you don't want to get confused.
So pick one in the exam.
Pick one. Before you go, when you're getting ready for the exam, you need to pick the one that you're more familiar with.
You could do either or in the exam, like the questions are tailored, like you can choose either or.
Yeah, you can choose either or.
Do with one. I like that you could choose either or, because I'm more familiar with it.
Yeah, but I mean for class, like because you know one, you do for class the opposite one. So your learning is more. But for the exam, you could go with the one that you're familiar with. Okay, so that's the second question. The third question you want to answer for Raven is, the liability for Raven is personally, if she enters into any contract on the company's behalf before the issue of the certificate of incorporation. Advise on that. Is that true or not true?
Sorry, liability for Raven is personal if entered on behalf of the company?
If she enters into any contracts on the company's behalf
Mhm.
before the issue of the certificate of incorporation. Advise on that.
Oh, I read this also, I could read it again.
The
No,
liability for Raven,
no,
personally,
Before the incorporation,
because she did it on behalf of the company, so it'd be personal and on the company, right?
No, she would not be.
no,
able to-
no, no, that ain't the right answer. Think again.
You said a liability for
The
Raven.
liability
Right to clause.
personally, if she enters into any contracts on the company's behalf before the issue of the certificate of incorporation.
Oh, before
Then
this,
she
okay,
would be
She would be
personally
personally
held
liable.
liable
Yeah.
unless she puts in her disclaimer within the
Yeah.
contract.
Right.
Or unless after the company is incorporated,
They ratify.
there you go.
Yeah, exactly.
Mhm.
For the contract.
Okay, so I'm gonna ask you another question. For several years, let me see. Beauties Limited, for several years, Beauties Limited has been carrying on the business of managing nightclubs.
Oh.
The directors are now proposing that the company should operate a chain of pizza restaurants. But some of the shareholders, they're objecting to this proposal. They really want to know, can they actually do this?
yes. Sorry.
The shareholders are objecting,
Mhm.
but the power lie within the directors, right?
No.
You have to
They
look
already
at their
have
memo and ours.
illegal business in the Bahamas, so all they would need to do is get a business license for the pizza.
Thank
company.
you. Mm-hmm.
So your question was with that?
Yeah, I need that question again.
Okay. For several years, I just say Beauty Limited, I give it a name,
Mm-hmm,
has been carrying on the business of managing nightclubs.
mm-hmm.
The directors are proposing that the company should operate a chain of pizza parlors.
Mm-hmm.
But some of the shareholders are objecting to this proposal. They want to know, is it permissible?
Is it permissible to
do what?
object
To
or
get
to
the
open
pizza
the
place?
pizza parlors?
To stop stop managing nightclubs and do the pizza.
Yeah.
The shareholders now.
Is the business of the company
Sorry, finish. I don't know.
limited to the shareholders or to the directors?
Business of the company is the business of the company.
But the directors are loyal to the company.
And the directors call the
shareholders.
shots.
Yeah.
Mhm.
Even though
Maybe
it's
that-
of
hold on,
shareholders,
hold on.
the directors.
We read a section tonight. Let me see who remember that section. Come on.
The rotation of the directors?
No. We read a section tonight.
You mean with the succession and the oh, gee, I
Talking
remember
about
that.
Schedule 1 under the memo and articles of association.
73.
No.
The powers of the directors?
No.
3, something shareholders agreement.
No.
Who? I heard it.
73.
What's it called?
I can't pronounce that first name, but shareholders agreement.
Unanimous shareholders agreement. Let's start from there.
Yeah, that's it though.
We did talk about that today. What does the section say in unanimous shareholders agreement?
All the shareholders of a company among themselves, or all the shareholders of a company and a person who is not a shareholder of a company may by a written agreement restrict in whole or in part the powers of the directors of the company to manage the business and affairs of the company, and such agreement, if not otherwise invalid, shall be valid.
But you said some of the shareholders are objecting.
Which means the directors cannot go ahead and create the pizza company.
But it didn't.
But if some are objecting and some are going for it, then wouldn't that be different?
Put it to a vote.
Put it to a vote. So to put it to a vote, then that goes to the next section. What kind of meeting should be called?
The shareholders meeting.
Yes. You see how, oh, I just love this question. Oh, I can put this on the exam. Huh? I could put this on the exam. You see, so you don't have to remember the numbers for the
Same thing.
Yeah, same thing. Yeah, but you need to remember.
Numbering is easy. Remembering the number and the
Yeah,
numbers.
see, okay. I can tell you one thing. Don't answer and say, that means nothing.
Oh, God.
That means absolutely nothing.
That's cold. What is section 7.3 is the right section?
No, it could be the right section, but I need to know you know what it means.
We know what it means, right? But
know what it means.
Yeah. So, okay. So I'm going to type these out and I'm going to email them to you directly. I can't remember how many minutes they give you. 4?
yeah, 4 or 5.
4 or 5. Okay. All right. So we'll end there for tonight. I'm going to send this. And so as soon as I send this, you could start writing out. Do not go to bed yet. It's not bedtime. You still have another hour.
Come on.
Thank you.
Yeah, you still have you still have another hour. So there's no going to bed.
When is
We'll
our
get a cup
deadline
of
to
tea.
send these?
Before class.
Okay, I just asking.
Yeah, before class. Unless something comes up. But on the weekend, you could take your time and write it out. So I'm going to send it now. While it's still fresh in your head, you could jot down your notes. And then on the weekend, you could type out your answers.
Okay.
That sounds good? Okay. As soon as my computer decided it wants to start. Okay, it's starting. Okay.
If this were,
It wasn't
were
starting.
exam questions, what amount of points would be allotted to them?
It depends how I write it.
No multiple choice, right?
You could, if you want it.
Oh, they scrambled my brain.
Okay, you don't have to have it.
No, I like the multiple choice.
Oh,
you
I
got
think you should
tonight.
have multiple choice. Should have a little bit of everything.
Yes.
It's best, but more multiple choice is better.
Yeah,
Sure?
I like the ones tonight.
You sure?
Yes.
Sure.
Oh, Dan, no.
No, Miss Archer. Let's have a balance. Have a balance.
Yes, have a balance.
But the question is, you want multiple choice?
You want
Yes.
multiple choice.
But she was saying,
That can kill you.
Exactly. They scrambled
With
my
doubt.
brain.
You circle something with multiple
Well,
choices.
You put something very
you
close to the
know,
answer.
it's either you know or you don't know. And the
Don't
point
know.
is to make you think.
That
Just
can
like
confuse you.
just like her asking the questions this evening, you notice she said she gave us 4 categories to choose from. And it was to make you think, okay, how does this work? How does it work with the law? What was said? And then you chose your answers based on that. It's the same thing. Either you write it out or you make it multiple.
Yeah. No, balance it out. I want all that. I lie. I think it's hard.
You all still have some time to think about it.
And people learn differently and they would
Yes,
answer questions
agreed.
differently. So
Yeah.
some persons may be better with short answers and essays, while others may be better with figuring out a multiple choice. So a good mix should be fair.
Agreed.
Okay.
I'm agreeing.
Say what?
I'm not agreeing.
You're
You know,
not?
the thing is, Lisa, I'm trying to stay quiet on that note because at the end of the day, it is the lecturer's choice.
Oh, I see. Oh, no, I give you what you want.
Okay. We could get a bonus question.
Now you're going too far.
I know, right?
It's dying too far.
Okay, sis.
A bonus question?
Yes, sis. You're too far.
I might save a little, mistake. That's the bonus question might bring a little.
Say a bonus question.
Lord have mercy.
That's really funny. I don't know. I'll see. I'm typing now. So you all could start to write it and let's see. I may add another one in here that
Okay.
we didn't discuss. I'll see if I have a different one from my past exam papers. And then you all could see if you could answer that one. You'll recognize which one is new.
Okay.
And then we could go from there. Okay, so get some tea or take a bath and you will see it very shortly.
All right.
Thank you.
Okay?
Bye.
Okay,
Bye.
talk to you next week.
Okay.
Good night.
Okay.
Good
Good
night.
night, everyone.
Thank you.
Okay, good night.
Right.
Fun class. Bye.
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 Good night.
Good night.